Inside a Michigan courtroom, a simple lease dispute turns into a legal chess match. A young student attorney faces a sharp-tongued judge, a tenant fights after suffering a stroke, and every word could tip the balance of justice. This is law in real time.
Come on. There is more.
There's more? Okay, go for it. I got all morning.
We are requesting permission to practice in your court under Michigan Court Rule 8.120 with the supervision of Miss Allen.
Have you been before me?
I have not, Your Honor.
I didn't think so. Where are you from?
I'm from Seattle, Washington, Your Honor.
Oh, it's really damp there. It's like rain, just rain. It's just, I don't know. Anyway, so where'd you go to undergrad?
The University of Washington in Seattle, Your Honor.
In today's courtroom, the tension begins calmly. Student attorneys from the University of Michigan step forward, introducing themselves before a sharp-witted judge who's already teasing them about their long introductions.
They beat my Maryland Terrapins, so you're in trouble. You should have said that was not the school.
I mean, I don't know if you know this, Your Honor, but I did switch sides after we lost the national championship. So I'm here at Michigan now. That's where my league.
You didn't belong in the game. Listen. Anyway, I don't even know why you were there, but that's okay. All right. So are you from Washington?
Yes, Your Honor.
All right. So you went to UW and now you're at Michigan.
Yes, Your Honor.
Okay, I'll let it pass. Permission to practice is granted. Go ahead. Good morning, Miss Sullivan. No.
Good morning, Judge.
The judge lightens the mood, joking about the attorney's hometown of Seattle. But behind the humor, he's testing confidence, gauging how the young lawyer handles courtroom pressure.
A residential lease agreement. We're seeking, basically going to be asking the court for a trial date for us to seek a judgment of possession. I will note, Judge, that I did receive, it looks like, an answer in affirmative defenses from defendants, as well as a demand for jury, as well as a motion for summary disposition. And so I think just looking for a scheduling order, Your Honor, to address all those issues.
Well, that's not entirely how we would do it. I guess the summary, since this is a summary proceeding, there's a question of whether or not rental payments were accepted.
Yes, Your Honor, that is correct. We did move.
As the case begins, we learn it's not about crime, but about tenancy termination, a battle over a residential lease where both sides have their evidence stacked and ready.
Our exhibits, the first of which being bank statements showing about 3 months worth of rent acceptance after the August 22nd move-out date specified on the notice to quit. The second exhibit we have is a signed HUD recertification signed by Mr. Fan and the building manager, Mr. Christopher Writings, if I'm pronouncing that correctly. That's from September 30th. And lastly, we have a notice of processing of that HUD recertification and a subsequent rent increase that was sent to Mr. Fan. That rent increase was actually set to take place tomorrow, all of which occurred, several months after the expiration of the notice to quit. And
the plaintiff's team requests a trial date, seeking possession of the property, while the defense pushes back, armed with documents showing rent was accepted even after the notice.
However, he has recently suffered a stroke, as a result of which his blood pressure consistently sort of reaches dangerous highs in stressful situations. So I just wanted to flag that for the court in case he does become unavailable momentarily. But in any event, for the sake of his health and on the basis of those pretty straightforward notice violations, yes, we are asking that you grant our motion to dismiss today.
Your Honor,
Yes, go ahead.
If I may address that, the Park Forest case doesn't apply here. This is not a non-payment of rent termination of tenancy. This is a termination of tenancy as it relates to multiple violations of, unauthorized
The judge, ever attentive, spots the legal twist. If rent was accepted after termination, did the landlord unknowingly allow the tenant to stay? That's the question shaking the...
Fine, except that the basic premise behind Park Forest isn't necessarily that it's a non-payment of rent case. The basic premise is that the landlord has done things that have led the tenant to believe that the tenancy continues, despite what their complaints may be, whether it be non-payment or whether it be termination.
Understood, Your Honor. Understood, Your Honor.
So,
if I may, Judge.
yeah, go ahead.
We have been engaged with Mr. Fan's prior counsel in negotiations of a settlement with respect to this issue. They have been on notice that we have been postponing filing the lawsuit as we engaged in those discussions. It wasn't a situation in the Park Forest where the tenant was led to believe that the notice to...
Then comes a human moment. The defense reveals their client, Mr. Fan, recently suffered a stroke. His health now hangs in the balance as the case proceeds.
Settlement discussions as a result, as it relates to that. As recent as end of September, Mr. Fan's prior counsel did identify that they could not reach an amicable resolution and suggested that we go ahead and file the complaint at that time. So this isn't a situation where Mr. Fan was led to believe that acceptance of rent or other actions waive that termination of tenancy notice. In fact, at all
I think that's going to be a factual determination. I don't know that one that I can make just on the thing. I understand what you may be saying, and I'm not sure. Well, I won't go into that. All right. So first thing is I'll need an answer to the motion for summary disposition. How much time do you need to do that, counsel?
The courtroom grows quiet. The judge listens carefully. Compassion meets law as everyone tries to balance justice with humanity.
Yeah, no, is it possible to, do you need an answer date or a hearing date?
Yeah, well, I just need, how much time are you going to need to file an answer, and then I can give you a hearing date?
If I could file an answer by the 14th, that would be sufficient time for me, Your Honor.
All right. So I'll indicate answer to motion by November 14th. I'm not going to need much time to necessarily look at that and grasp the issues. So when's my next Tuesday? 3? No.
Oh, Tuesday, sorry. December 2nd, after that.
That's my next day.
I'm sorry, November 18th.
November 18th. I can.
The opposing attorney fires back, arguing this wasn't about unpaid rent, but about damaged property, unauthorized changes, and aggressive behavior. The tone shifts from calm to confrontation.
And I will set it for a hearing on the motion and a pretrial for November 18th. That's an in-person hearing. That's a Tuesday, and that will be at 9 a.m. And then I'll hear argument on it and then we'll see whether we go forward.
Thank you, Your Honor. Judge, I'm sorry, Your Honor.
Yeah.
One housekeeping matter. I will note that Mr. Fan filed a complaint against Mr. Ridings in a separate matter. Is that it's case number 254.
The judge cuts in again, reminding both sides that the law isn't just about rules, it's about what the actions meant. Did the landlord's behavior signal forgiveness or enforcement?
No, but you have it.
I do. That was filed as a general civil matter.
So it's before Judge Barr.
Correct.
Okay. When was that? When was it filed?
It was filed on September 29th, and I'm not seeing any activity past that.
So nothing has gone forward on it. All right. What I will do, I don't know that I can give you a straightforward answer. It's likely that what we'll do is we'll contact Judge Barr and probably bring it over because it doesn't make sense I don't know what the issues are in that filing, but it would seem to me that if they...
In the end, the judge sets a future hearing, keeping both parties on track. The battle isn't over, But one thing's clear. Every word, every document, and every delay will matter when Judgment Day arrives.